Attorney Joe McPeak with Virtuoso Criminal and DUI Lawyers. Today I'm going to talk about the crime of elder abuse, which is codified in California Penal Code Section 368. The crime of elder abuse is kind of complicated in that there are a couple of different ways that a person could be found guilty of committing it. So let's start with a breakdown. The best resource is really to find out the elements of the offense, especially on a complicated charge like this, are the California criminal jury instructions. You can look them up online. The first way to commit elder abuse is if the defendant willfully caused injury to somebody who is 65 years of age or older. In those situations, the allegation is usually that the defendant or my client actually just directly injured somebody and caused them what they say unjustifiable pain or suffering. It could be a type of case that you would see as maybe under other circumstances might also be categorized as a battery under Penal Code Section 242, for example. But in this situation, it's also categorized as elder abuse because the defendant willfully caused physical pain or suffering to somebody who's 65 years of age or older. But not all cases of elder abuse are as direct or straightforward. In some cases, the argument is that the defendant caused the elder person to suffer pain, or in situations where the defendant is a supposed caretaker or a functional caretaker role for the elder person and just fell so far short of their duties that the elder person suffered, or maybe they didn't even suffer, but they were put in a position where their health was so greatly at danger. The other way is where the defendant willfully caused or permitted the elder person to suffer unjustifiable physical pain or suffering. Note, that's different from the first, where the defendant is accused of actually just causing it. Permitted the elder person to just suffer it is slightly different. So it's sort of like not so much an affirmative act, but more of an omission perhaps by the defendant. And then there are more layers. If the defendant, while having care or custody or control of the elder, permitted that person to suffer in health or cause them to be injured. And there's the other situation where the defendant, while having custody of the elder person, permitted them to be placed in danger, where they didn't actually suffer any harm necessarily, but they permitted them to be placed in a situation where their health was in danger. These are all the situations where a defendant could be convicted of elder abuse under that code section. One thing to know, under that last alternative, the defendant, when they acted, they need to have known or reasonably should have known that this act or omission by them would have actually caused the elder to suffer this way, and that they knew this person was actually 65 or older. And in this situation, the prosecution has to prove that the defendant had a legal duty to act, a legal duty to care for the person. They had a legal duty to supervise or control, is the language the jury instruction used. A legal duty to supervise or control the conduct of the persons who caused the unjustifiable physical pain. So you could imagine a situation where perhaps somebody who's in charge of caretakers is sort of indirectly responsible for the endangerment or the injury to the elder person. Those people can be held just as responsible under California Penal Code Section 361. So this is a statute that really covers a lot of different ways where a person's conduct or non-conduct, however attenuated in time, is still actually found culpable in certain ways. What did we look into? You look into the context of the relationship between the defendant and the elder victim. So what are the penalties for 361 if you're convicted? Well, 361 is a wobbler, so it can be prosecuted as a misdemeanor. And that means as a misdemeanor, you can get up to a year in county jail, and that could or could not be combined with a grant of probation. As a felony, there could also be a grant of probation with some county jail, or alternatively, you could get up to 4 years in state prison, or up to 7 years in prison if it's found that the elder victim suffered great bodily harm. So these are all sorts of different iterations that you and your defense attorney need to be on the watch for when defending a charge of elder abuse under Section 361. One other thing to know. You may know from some of our other videos and from your own research that probation has been severely limited in California for a lot of offenses. For misdemeanors, most of the time the probation you can get is no more than 1 year. For a lot of felonies, the most probation you can get is 2 years. Not so with elder abuse. It is not so limited by the same statutory caps. So watch out for that if you're staring down a conviction for Penal Code Section 361. You might be on some form of supervision for a longer period of time than expected for other types of charges. The brunt of what you got to know from this is that defense of an elder abuse claim involves a really careful inspection of exactly how the harm or endangerment came about to the elder person, and what is the exact scope of the relationship between the defendant and the elder person. Every case is different, but these are usually the two key issues that I think come into play here. Whether the defendant really had a legal duty to act, to control or supervise the people who are caring for the elder person. These are all the things that I think need to be looked into. Thanks for watching. For this and similar videos, feel free to check our website, our Instagram page, and our YouTube channel. Stay safe out there.